News Corp UK and Ireland Committee against Commissioner for His Majesty Revenue and Customs.
Good morning, Mr. Peacock. I'm sorry for the delay. As you all have seen, it was a computer problem that held us up. If we need to adjust the times, we can do.
My Lord, I'm grateful. My Lords, good morning. I appear for the Appellant News Corp with my own friends Mr. Brown and Mr. Hellier. My own friends Mr. Metrofanus and Mr. Donnelly appear for the Respondent Commissioners. I would propose, if it's convenient to your Lordships, to address you under 5 headings. Firstly, some observations by way of introduction. Secondly, the UK legislation and its interpretation. Thirdly, the EU legislative regime and its application here. Fourthly, the principle of fiscal neutrality. And then fifthly, where then do we say that the Court of Appeal erred in law? So beginning with some observations by way of introduction, as your Lordships would have seen, this appeal is concerned with the interpretation of the term used in the VAT legislation by which zero rating treatment, that is, output tax at the zero rate with recovery of input tax, is conferred by Section 30 and Schedule 8 of the VAT Act of 1994 on goods or services, provided that those goods or services are of a description specified in Schedule 8, that specified description here being newspaper. Now, in identifying the proper interpretation of that term in Schedule 8 and in deciding whether the Court of Appeal erred in law, in overturning the decision of the upper tribunal, the Court will be required to consider and apply a number of different principles of interpretation which all operate on this particular question. I will address those in turn, necessarily dealing with them separately, but it is important in our view to state at the outset that all such principles must be read eventually together in what is ultimately a single exercise of statutory construction. So putting it as neutrally as I can, is a digital edition of the Times, or the Sunday Times, or the Sun, within the specified description of a, quotes, newspaper? Now, in beginning to address that question, there are 5 matters by way of background that I wish particularly to emphasise. First, we're concerned with the particular clearly defined social reason being the purpose which justifies the adoption and maintenance of the zero rate in the UK for newspapers. And that is the subject of a finding by the first-tier tribunal, it's paragraph 17, namely that that purpose is the promotion of literacy, the dissemination of knowledge, and the promotion of democratic accountability by having informed public debate. There is a similar explanation, this time as regards books rather than newspapers, in the colour offset case and the submissions there of Mr. Richards, as he then was, for Customs and Excise, where the legislative purpose is described as avoiding a tax on reading.
And the reference to that?
It's in the first volume of Authorities, tab 37, and it's page 501, D to E.
And the electronic page?
That should be 501.
Thank you.
Yes, you need only give us the electronic page because we don't have tabs and volumes anymore.
Yes.
Thank you.
Now, the Court of Appeal purported to identify some narrower, albeit unspecified, purpose for the zero rating here. It's paragraph 71 at Key Documents, page 88. I'll come back to that, but we say there's no basis for that identified narrower purpose. Now, that social purpose applies, we say, just as much to digital editions of the Times as it does to paper editions. And that was something accepted by the first tier at its paragraph 200, which is Key Documents, page 155. Now, as a matter of principle, we say that must be right. Literacy, knowledge, democratic accountability are just as much advanced by a print copy of the Times as by a digital edition. What matters is the content or the message and not the medium. Now, a point I will come back to, we do not say that that alone is sufficient to get us home. But it is a necessary element which is present here. Second, by way of background, the appeal is concerned with the different types of digital edition which are set out in the decisions below. As your lordships will have seen, there is an e-reader or PDF version, which is an exact facsimile copy of the print. There's a tablet edition, which is derived from the printed edition, which can be downloaded and read offline. There's a smartphone edition, again downloadable and capable of being read offline. And then there's the website edition, which is accessible through an internet browser. We see no relevant difference between each type of digital edition, and no such differences were identified below. The commissioners here say we are not entitled to 0 rating on any of them. We say we're entitled to 0 rating in relation to all of them. Thirdly, consideration of the relevant legal issues here in part requires an appreciation of whether the digital editions are the same or similar to the print edition. Now, that exercise of comparability was done by the first-tier tribunal, which concluded that the digital editions had similar characteristics to print editions. That's first-tier paragraph 150, key document page 144. And that the content of digital and print was fundamentally the same or very similar, first tier at 153, key documents page 144. The first tier also found relevantly that what mattered to readers was the content rather than the medium of its delivery, and readers saw the digital editions and the print editions as fundamentally the same. Both of those references found in the first tier at paragraph 156, key documents page 145. Those and related findings were challenged on appeal to the upper tribunal, and such challenges rejected. Permission to appeal further to the Court of Appeal was refused, so in this court, therefore, the first tier's conclusions as to comparability are beyond challenge, something which my friend's written case does seem to forget from time to time. So pausing there, the digital editions are fundamentally the same as the print editions, and they further the same social policy goals. One is then entitled to ask, what reason is there for a difference in tax treatment? Now, I quite accept that there might be such a reason, but we do say that reason needs to be a good one. And of course, the effect of the Court of Appeal decision below is that a print subscriber to the Times buys a 0-rated product, and a digital subscriber who perhaps doesn't want to rely on a paper delivery, he or she buys a standard-rated product, even where the digital version is a PDF copy of the print. Not so, we say. Fourthly, by way of background, we are only actually here concerned with the Times, the Sunday Times, and the Sun. We are not concerned with what are termed rolling news websites on the one hand, or with e-books on the other. Book publishers will no doubt be very interested in the outcome of this appeal, but there are no relevant findings of fact here about e-books or the comparability or otherwise of e-books with print books. This appeal is only concerned with newspapers. And then lastly, by way of introduction, there were other consequential issues left outstanding by the first tier. So quantum here is not agreed. If we don't get home on all of the digital editions, there may be further arguments about apportionment, which would fuel the debate about quantum. And there is also possibly a debate about a VAT concept of unjust enrichment as to who bore the burden of the VAT that was accounted for here. All of those are for another day, and they will be resolved in the first tier in due course in light of the judgment that this court arrives at.
Yes, it would be the last point would be a possible passing on defence, presumably.
It's exactly that debate, my lord, yes. And that was left outstanding in the first tier, and so one outcome of this appeal is we go back to the first tier for those issues to be addressed. So that's what I say by way of introduction. That takes me to my second main heading, the UK legislation and its interpretation. And I begin by making clear again that one cannot look at the UK position in isolation, and one does have to address the EU legislative regime in arriving at the answer to the relevant question of statutory interpretation here. But we do have to start somewhere, and for various reasons we say the UK legislation is the proper place to start. As for the legislation itself, a number of observations I should make about the UK statutory provisions. And here it would help just to have to hand the VAT Act 1994, which is in the authorities at page 60, where you should find section 30 of the 1994 Act. And this is, in effect, the same as the 1972 Act. It provided for zero rating. But Section 30 provides for zero rating for goods or services. Section 30, subsection 1, so it can be either. But subsection 2 makes clear that a supply will be zero rated if the goods or services are of a description for the time being specified in Schedule 8. The relevant question ultimately is going to be whether a particular item falls within the description provided for in Schedule 8. Before turning to Schedule 8 itself, it is important in our submission here just to note Section 96 of the Act, so it's the 1994 Act, which begins at page 64, other interpretive provisions. But here we're particularly interested in subsections 9 and 10. Subsection 9 on page 66 makes clear that the schedule shall be interpreted in accordance with the notes contained in the schedules. And then subsection 10, 9610, the descriptions of groups in those schedules are for ease of reference only and shall not affect the interpretation of the description of items in those groups. So we'll see in a moment that the groups are given a title. But subsection 10 makes clear that that is for ease of reference only. And if one wants to understand the scope of the items within the groups, then one needs to look at the language which is used in the items themselves. And then turning to Schedule 8, which you'll find at page 70, we're here concerned with Group 3, so headed books, etc. And then there are a number of items listed. We're here concerned with item 2, newspapers, journals and periodicals. No reference there to printed or in print. And that forms part of a list, items 1 to 6, which were in place in 1972, as we'll see in a moment, extending from books in 1 through to item 6, covers cases and other articles supplied with items 1 to 5 and not separately accounted for. So that makes obvious sense if one looks at cases and bears in mind item 5 is maps, so you might have a case for a map. One can see how that fits together. But 6 extends to covers cases and other articles. And then if one notes just for now, item 7 is new. This was introduced in May of 2020. So item 7 provides for zero rating for the publications listed in items 1 to 3. There's a noun there used, a collective noun for the items in 1 to 3 are publications. When supplied electronically, So the post-2020 legislation refers back to newspaper being a publication supplied electronically, but excluding publications which are wholly or predominantly devoted to advertising or consist wholly or predominantly of audio or video content, top of page 71. So item 7 was when the law changed, but that is May 2020 onwards. Prior to that, we were only concerned with items 1 to 6. So as a basic formulation, 0 rating is provided for in section 30, goods or services, and one is looking for an item that satisfies the description found in Schedule 8, and then that requires one to look here to Group 3 and here in particular to item 2.
Can I just ask a question about, it may be that you want to deal with this at a different part of your submissions, but the new legislation, while we've got it open in front of us, is an extension to electronically supplied newspapers, but then has an exclusion. At some stage, I'd like to hear what you then say, how that fits with your principal submission, I think, that at that point in time, newspapers were already electronically, could already be supplied electronically, and how, for example, that new provision sits with the interpretation that you're favouring that was already in place.
Well, I am going to deal with that, but if I just anticipate your Lordship's point for a moment, it can be said that item 7 was needed because items 1 to 6 did not go as far as I would wish them to go. That we say is not right. Item 7 puts beyond doubt what the position was and would be going forward, but also serves to make clear that even a publication that falls within items 1, 2 and 3, say a journal or a periodical, to stay away from newspaper for a moment, would be excluded if it satisfied either little a or little b. I'm going to come back and put that into better context in a little while.
But you essentially are saying it's clarificatory of what was largely there, but then it cuts it back in some respect, does it?
Well, the effect of A and B is to limit that scope, yes.
Thank you.
Now, if we just turn back to pages 48 and 49, I need to show you the Finance Act 1972. So page 46 has the equivalent of section 30, which was then section 12, 0 rating, and it's page 49 that has group 3, books, etc., where you see the same items in 1 to 6. And there are differences, and not as regards items 1 to 6, but as regards the notes. I'm going to come back to that in a little while. So in 1972, there was only one note, whereas by 1994 and by 2011, there are more notes. I'm going to come to that in a little while. But to save coming back, because it is a feature of the decisions below, Group 4 in 1972 provided a 0 rating for talking books for the blind, just the heading. But what was then 0 rated was actually the supply of particular items, physical items, So if one looks in Group 4, as it then stood, it was magnetic tapes, little a, tape recorders, little b, and parts and accessories, little c. Although the heading talks in terms of talking books, what was actually zero rated was the supply of physical items. Returning to the legislation in its modern form, and looking at page 71, one sees the notes that are now part of this group. What is now Note 1 was the original note in 1972. It does not include plans or drawings for industrial, architectural, engineering, commercial or similar purposes. What is now Note 1 capital A came in 1978. And that provides that items 1 to 6 include the supply of the services described in paragraph 1.1 of Schedule 4 in respect of goods comprised in the items. I'll come to that in a second. And then what is now items 2 and 2A and 3 all came in 2011. There's a small point here which in our submission is not ultimately going to matter, but the note that came in 2011 doesn't extend to all of the relevant period to this appeal, because our claim runs from 2010 and the 2011 note came in, I believe, July of 2011. Just going back to Note 1 capital A, that came in 1978 to make clear that the supply of particular types of services in respect of goods comprised in the items would themselves be zero rated. And those particular types of services were the supply of an undivided share or of possession of an item in items 1 to 6. And from 1978 onwards, they were treated as supplies of services rather than goods. So if you sold a book, that was a supply of goods. If you lent a book, you provided possession but not a transfer of title, that was treated as a supply of services. And as a consequence of that change in 1978, this note was introduced to make clear that the supply of those services in relation to the items in 1 to 6 would themselves be zero rated. It's easier to see the rationale for that in relation to books, but if you charged a fee in a lending library, you were providing possession of the book, and that was a zero-rated service, but it was this note that made it zero-rated. And the 2011 note was brought in ultimately to deal with a decision of the Court of Appeal in a case called Telewest, where a taxpayer provided a TV service and a magazine that listed the television programs, and that taxpayer decided to set up a separate company to supply the magazine on the basis that it would be zero rated and separate from the standard rated supply of the TV service. And the commissioners ran an argument in the courts to say that even though it was supplied by two different parties, it should be treated as if it were one supply of a taxable service. And that argument was rejected by the Court of Appeal in Telewest. And in consequence, ultimately, the law here was changed to make clear that if you engage in that type of supply splitting, then you don't benefit from the zero rating. And so the effect of that, when read with the other notes, are that we are told that whatever is otherwise the scope of here newspaper, we're told by what is now Note 1 from 1972 onwards, well, those items don't include certain things, they're listed. We're told by Note 1A that it does include certain services in relation to those items. And then we're told by Notes 2, 2A and 3 that items 1 to 6 don't include goods in circumstances where there are related supplies of services by a connected person. The 2011 note is an anti-avoidance rule designed to deal with particular types of transactions.
But I'm right in understanding what you've said, that it's no part of your submissions that the services that we're here dealing with today, i.e. electronically supplied services, they weren't in any sense connected with the word supply of services in connection with goods.
No,
under these notes.
We are not within those notes.
Thank you.
Yeah, there may well be a debate as to what you can glean about the purpose of the provision and its ambit from the fact that specific provision was made to deal with the transfer of an undivided share and or possession. And I'm going to say in due course that one can't infer anything from that. It's a note designed to deal with a particular problem, but that problem is unrelated to the scope of newspaper.
Have we got the authority, the Telewest, I think you described it as, is that in the bundle or not?
It's in the supplementary bundle.
Thank you.
It's in the supplementary bundle at page 116. Just whilst I have those pages open, just to note, page 74, that Group 4, Talking Books, is still there, still part of the VAT code, although it has been expanded, but it's expanded in a way that it now covers more physical items. So it's magnetic tape and then different sorts of apparatus and parts and accessories, or the supply of service or repair or maintenance of goods described above. Now, here, our relevant term is newspaper, which appears as part of a wider statutory phrase, newspapers, journals, periodicals, all clearly referring to publications, with the sense, we say, admittedly still at a high level of generality, of the provision of news or comment or commentary, commonly with some degree of regularity. Now, it may be journal in particular is used in the sense of a newspaper. There are no doubt mastheads of newspapers in this country that bear the name journal. But equally, it would extend to scientific journals, for example. That would be a journal that would be capable of being delivered in print, or now, in the modern world, capable of being delivered digitally. So that gives effect to the social policy goal that impressed Parliament in 1972 to give zero rating treatment to newspapers. And as your lordships will no doubt be aware, newspapers have long had a favourable tax treatment for, in effect, the same reasons if one goes back into the history of time. But perhaps most immediately relevant, there was a tax in the UK called purchase tax that ran right up to the introduction of VAT, and newspapers were not subject to purchase tax. There was a suggestion in 1940 that they would be covered by purchase tax, and then there was a huge row in Parliament, and the government of the day backed off in August of 1940. So our relevant term is newspaper, as part of that wider phrase of newspaper, journals and periodicals. What then is the relevant approach to statutory interpretation here? It should be, and I think is common ground, that the statutory interpretation of the relevant term is concerned to identify the meaning of words used by Parliament, looking in particular to context and the purpose of the provision. And that relevant approach was summarised very recently in this court in the registration of British children case, in particular by my Lord Hodge at paragraphs 28 through to 31. And that may be helpful just to turn that up. It's page 683. The report begins at 673, and then it's my Lord's paragraphs 28 through to 31, 28 beginning on page 683. Having regard to the way in which both parties presented their cases, it is opportune to say something about the process of statutory interpretation. And we accept and endorse what my Lord had to say in 28, 29. 30 is about external aids to interpretation, which doesn't directly arise here. But then in particular, paragraph 31 at page 684, statutory interpretation involves an objective assessment of the meaning which a reasonable legislature as a body would be seeking to convey in using the statutory words which are being considered. And then there's a citation from Lord Nichols in the Spath-Home case, making the point within that citation that the meaning and indeed the intention of Parliament is an objective concept, not subjective. The phrase is a shorthand reference to the intention which the court reasonably imputes to Parliament in respect of the language used. Now, that is sometimes described as an exercise in discerning Parliament's intention. That is often a rather difficult concept to pin down. For our part, we would say it's better expressed as an exercise in seeking to identify the purpose of the provision, read in the context of the Act as a whole, in light of the words that Parliament has used. Now, that search for a purposive meaning in a modern context can involve a departure from what might be the natural meaning of a term, but that we say is not itself objectionable, provided the court bears in mind that such a process is simply a different analytical technique to ascertain the meaning of the relevant words. And here we do place some reliance on what is now a slightly old case, but there's a passage in the speech of Lord Simon in the Frank Jones case, which is quoted in our written case at paragraph 12. But it may be useful just to turn this up. It's at page 876 in the authorities manual. Decision of the House of Lords about workers who were dismissed when on strike, and the debate was whether they had been unfairly dismissed. I'm obviously not concerned with that. But Lord Simon's speech begins at page 880, and the passage that we particularly place reliance upon after he'd introduced the issue by reference to the Golden Rule and the Mischief Rule, is between letters E and G on page 881, and I don't propose to read this out to your lordships, but you'll see there the passage that we rely upon. It's essential to bear in mind what the court is doing. It's not declaring Parliament has said X, but obviously meant Y. And then picking it up 5 lines down, what the court is declaring is Parliament has used words which are capable of meaning X or Y, although X may be the primary, natural and ordinary words, the purpose of the provision shows that the secondary sense Y should be given to the words. And then 2 lines down, the final task of construction is still, as always, to ascertain the meaning of what the draftsman has said, rather than to ascertain what the draftsman meant to say. So we would accept and endorse that, and say that we are looking for the purposive meaning of the term used, here read in context. Now, putting aside the particular statutory provision just for a moment, what is meant by a newspaper? We say it is a publication that provides edition-based, curated news and comment, typically daily, but it might be weekly, so there is a regularity to the production of editions. But the core characteristics are that it is edition-based and curated news and comment. And we say there's nothing inherent in the term newspaper as a noun, read in the modern context, which precludes a digital edition. And we accept and recognise that it's not a defined term in our Act, nor is it a term of art in the VAT Code, nor is there any indication here that it has a specialist or a technical meaning. Instead, one has to give it, in its context here, a purposive, appropriately contextual meaning. So I turn now to what that purposive meaning is in context. I've made this point by way of observation in opening, but the purpose of the relevant provision here, which zero rates the supply of a newspaper, is that identified by the first-tier tribunal. It's paragraph 17, which it, the first-tier tribunal, found to apply equally to digital editions. There was no relevant difference in the satisfaction of that purpose, the promotion of literacy, the dissemination of knowledge, and the promotion of democratic accountability. It did not matter whether that was in print or digital. And we would say those purposes are just as much furthered by a digital edition of the Times today as was a print edition in the 1970s. Indeed, arguably, it's more important now as our lives collectively move further and further online. And we say there's nothing in that particular purpose that requires an interpretation of newspaper which is limited to print. There is no inherent requirement in the term itself that one has to be able to use it as kindling or to wrap fish and chips. It's the delivery of the content that furthers the purpose. It's not the medium by which that content is delivered.
Although, of course, that purpose would equally well be served by wider, somewhat analogous situations such as rolling news services. But your point is, but they're not newspapers.
Well, Lord, yes, and I was careful to accept at the outset that that's a necessary waypoint on my way home, but it's not a sufficient one. I can't say that anything that has that common purpose gets home as a newspaper. It also has to have what we say are the core characteristics of a newspaper, being edition-based, periodically produced, curated news. So the purpose is equally furthered by digital as it is by print. What then of the context? Well, the context here, going back to section 30, is that Parliament has determined that there shall be a zero rating treatment for goods or services. So you're not limited to one or the other. But what you have to satisfy is you have to be able to show that you are of a description in one of the items. It's an exercise in determining whether a given item properly falls within a description. That descriptive term here being newspapers. Now, a small digression, it was a point that exercised the Court of Appeal for a little while, is there is no difference in principle between goods and services for the purposes of VAT. VAT is a tax on consumption, whether that consumption is in goods or services, and as a matter of principle, the supply of goods and services should be treated the same. And that's a point that was, in a sense, one might think it would be obvious, but it was emphasised by the Court of Justice in the RPO case at paragraph 50, and that's page 405 of the authorities bundle. And it would be helpful, Lord, just to turn this up. RPO, it's an abbreviation, not the full name, but the judgment of the court begins at page 397. It's part of a debate in the European Court about reduced rates of VAT supplied to books supplied digitally. But the court begins its analysis, paragraph 50, page 405, by making clear that there is in principle no difference between the supply of goods and the supply of services. So the fact that one supply is goods, here a printed newspaper, and the other supply is services, here a digital edition, in principle should make no difference. Ultimately, what one has to decide is whether a digital edition satisfies the UK statutory term, but there is no barrier that one is goods and one is services. So do other aspects of the surrounding context indicate that newspaper here is limited to a paper printed edition in physical form? The first-tier tribunal in the Court of Appeal said yes. The upper tribunal said no. And here again, it would be useful to turn up Schedule 8, Group 3. So this is back to page 70. Where I make these points. Firstly, there's no express reference in item 2 to printed newspapers or newspapers in print. Item 2 does not express a view about the medium by which the content of a newspaper, a journal, or a periodical is delivered. Item 4 in that list does contain a qualification. So item 4 is explicitly limited to printed, duplicated, or manuscript music. Now, we understand that to be a deliberate choice made to exclude music in audio form. Then it would have been vinyl. I can't quite remember whether it would by then have been a cassette. It wouldn't have been a DVD or a CD. But it was an exclusion of music in audio form by making clear that it had to be printed, duplicated, or manuscript. but there are no other express limitations in those items listed in 1 to 6. Now, it is true, and was held against us below, that item 6 refers clearly to physical items that are supplied with items in 1 to 5. What was said below, and we say is wrong, is that because item 6 is limited to physical items, that allows you to conclude that items 1 to 5 are limited to physical items. We say that does not follow at all. Item 6 is dealing with a world in which physical items are supplied with items 1 to 5. It's not telling you that items 1 to 5 are limited to goods. Equally, the note that was in place in 1972...
One can see that perhaps in a way from the fact that it's remained unchanged since 7 has been added.
My Lord, yes. Now, I am wary of running into an argument about whether one can infer a purpose in 1972 by looking at what happened in 2020, but it is clear, I can perhaps put it no higher, that Parliament is content to continue to use the word newspaper.
Well, I was just focusing on the covers point. That the covers and cases,
My Lord, that's
had it followed from that only physical items were intended, or was then they would have needed to change 6 when introducing 7.
My Lord, that is also true. Yes, I see that. What was the first original note in 1972, now note 1, excluding industrial plans and drawings, doesn't tell us anything about the scope of 1 to 5. A point I've already made, but let me reiterate. Note 1A that came in 1978, dealing with particular types of transaction that were types of service, tells you that you have to make provision for the transfer of an undivided share or possession. It's not actually telling you anything about the ambit of the terms in items 1 to 5. And then notes 2, 2A and 3 come along in 2011 for an anti-avoidance reason to do with supply splitting. But one can't infer from those notes, even if it's appropriate to look at them, that items 1 to 5 are limited to print or physical items. Now, it was these points that led the first tier, amongst others, to conclude that the context was fatal to my argument, and these factors were regarded as strong and significant by my lady in the Court of Appeal, again pointing against my argument. But they are, we say, accurately analysed and summarised as to their effect in the decision of the upper tribunal, which recognises that they are all explicable by the fact that goods are included in items 1 to 5, but they are not a basis on which to conclude that only goods are included in items 1 to 5. And there is a grave danger here, which I'll come to in a little while to develop a little further, in proceeding from perfectly reasonable conclusion that Parliament could only have had print newspapers in mind in 1972, to the conclusion that Parliament determined that the scope of this provision would always be limited to newspapers in print. One can quite readily accept the premise of that, but the conclusion just doesn't follow at all. And certainly there is nothing in items 1 to 5 themselves that would drive that conclusion. do we say there's nothing in a purposive reading in context here which requires the limitation of the term newspapers to a printed edition. I pause there, still under the heading of UK statutory interpretation. I need to address always speaking. Now, if one might conclude that the purposive construction of newspaper in the context of these provisions does not preclude a digital edition, so we're not limited to print, we do still have to deal with the fact that such digital editions were not known to Parliament in 1972. Now, small digression here. The same statutory language that appeared in the 1972 Act appeared when the statute was consolidated in 1983, and the same again when it was consolidated in 1994. You've seen the 1994 Act, you've seen the 1972 Act. There's one I haven't bothered to show you in the middle, but it is to almost word-for-word like effect. So when we come to think of the exercise we're doing, we're actually construing the legislation in 1994, but that relevantly is the same as it was in 1972, with the differences I've identified in relation to the notes. But it is the case that Parliament could not have contemplated digital editions in 1972, or in 1983, or probably in 1994. This is not, there's no finding of fact to this, but there is some evidence, if one looks around the world, that the first digital newspapers were in the States sometime in the early 1990s.
I'm sorry. Are you accepting that Parliament didn't contemplate digital editions in 1994?
What I was accepting is that Parliament could not have had in view digital editions because there weren't any.
Yes, in 1994.
In 1994.
Yeah.
Well, certainly in 1972, certainly in 1983, and I got no evidence to say that there was clearly such a thing even in 1994. If one looks back around the world and does a trawl, there are some items in the early 90s, but not so obviously prevalent that they must have been obvious to Parliament. So if that's right, if it can be said that Parliament cannot have had in its view digital newspapers, does it follow from that that the term newspaper in Group 3 must now be read as referring to print only? And we say no. As your lordships are well aware, there is a principle of interpretation, UK statutory interpretation, that is designed to deal specifically with such a state of affairs, so the always speaking principle, the effect of which is that when Parliament uses a particular term in enacting a provision, and the circumstances in which it might apply develop as a result of changes in social attitudes or technology, for example, the courts are entitled, indeed required, to consider whether there is a contemporary application of the term which should be given effect to in modern circumstances. And the case law establishes that courts will do that if they are satisfied that the genus of the new circumstance is the same as that of the old, or if there is a clear legislative purpose behind the application of a particular term to the old circumstance, which would be frustrated if the term did not apply to the new circumstance. Your lordships will be well aware of these authorities, so let me take what appear to us to be the most relevant ones in chronological order. I'll do this as quickly as I can. But starting with the Quinterval case, which is pages 705 and 706 in particular the speech of Lord Bingham.
So could you give me the page number again, please?
705, 706.
Thank you.
So the case itself begins at 697. This was the case about the definition of embryo, and did it reflect the modern techniques by which embryos would be created. So this is a case in part about social attitudes, but also in part about technology. And the judgment of, so the speech of Lord Bingham begins at 702, but the relevant passages from my part, he begins at 704 with a heading, the approach to interpretation. And then in particular, it is paragraph 7 through to 10. He begins, such as the skill of parliamentary draftsmen, that most statutory enactments are expressed in language which is clear and unambiguous and gives rise to no serious controversy. That's not always the case. And then reading on to the end of 7, he said there are examples, perhaps because the statutory language is said to be inapt to apply to it, sometimes because the situation which has arisen is one which the draftsman could not have foreseen and for which he has accordingly made no express provision. And he goes on, the basic task of the court is to ascertain and give effect to the true meaning of what Parliament has said in the enactment to be construed. But that's not limited to a confined and literal interpretation. And then at the end of that paragraph, I don't want to read it out to your lordships, but he says this, between letters D and D, the court's task within the permissible bounds of interpretation is to give effect to Parliament's purpose. So the controversial provision should be read in the context of the statute as a whole, and the statute as a whole should be read in the historical context of the situation which led to its enactment. And quite a well-known passage in 9, there's no inconsistency between the rule that statutory language retains the meaning it had when Parliament used it, and the rule that a statute is always speaking. And he gives his example of dogs and cats. And then in his paragraph 10, he endorses the guidance of Lord Wilberforce in the Royal College of Nursing case, which is set out on page 706. I don't want to read it out to your lordships, but we do accept and endorse what Lord Wilberforce had to say there. It's between letters C and D, where his lordship puts it this way, in deciding whether they fall within the parliamentary intention, they may be held to do so if they fall within the same genus of facts as those to which the express policy has been formulated. They may also be held to do so if there can be detected a clear purpose of the legislation which can only be fulfilled if the extension is made. And his lordship goes on to say how liberally these principles may be applied depends on the nature of the enactment and the strictness or otherwise of the words which in which it has been expressed. And something my learned friend relies upon, and I'll deal with in due course, the court should be less willing to extend express meanings if it is clear that the act in question was designed to be restricted or circumscribed in its operation. But it's also of some relevance in this particular appeal to see how Lord Bingham applied these principles in that particular case. And if one picks it up at page 707, paragraph 14, he's dealing here with the definition of embryo, and he makes, he refers to Mr. Gordon's construction has an obvious attraction. The act is dealing with live human embryos where fertilization is complete, and the definition is a composite one, including the last 4 words. And then he says this at letter F, can Parliament have been intending to distinguish between live human embryos produced by fertilization of the female egg and live human embryos produced without such fertilization? The answer must certainly be negative, since Parliament was unaware that the latter alternative was physically possible. Just pausing there for a moment, what he says is that, well, Parliament could not have known of this new technique, and therefore it cannot be taken to have expressly excluded it. Now, for my part, that's an attractive way of putting the point. Parliament cannot be expected to have known about digital editions of newspapers. It can't be taken to have deliberately excluded them from the provision.
Sorry, which is the passage? I've not quite got that particular passage that you're directing.
Letter F, I think.
F, beginning, can Parliament have been intended?
Thank you.
It's those two sentences. He said, well, can Parliament have been intending to exclude A from B? And he says no, because Parliament was unaware that you could do B.
Why is that reasoning any better than the reasoning that because Parliament didn't know about the possibility of digital editions, it can't have intended to permit them? And it seems to be just as bad an argument.
Well, the way he puts it is, for obvious forensic reasons, you see why it's attractive to me. I quite recognise that, of course, if that were right, it would lead or tend to the conclusion that you would always apply always speaking. Because as soon as you're dealing with a state of affairs that can't have been within the knowledge of Parliament at the time, if that led you to the conclusion, well, it can't have been excluded, that leads you logically to the conclusion that always speaking would always apply. And that
proves too much.
It proves too much. But what was it that drove his lordship to that conclusion in that case is apparent, we say, from the rest of paragraph 14. How he gets there is because that conclusion gives full and proper effect to the purpose of the provision. So reading the legislation as involving no implied exclusion best gave effect to the purpose of that provision.
There was only one way of creating embryos at the time, but that was irrelevant to the purpose.
My Lord, yes. So one can't read what he says at letter F really out of context because, as my Lord identifies, there's a danger it proves way too much. But it is an interesting waypoint on the way to his conclusion, which is driven by the purpose of the provision. I invite your lordships, perhaps in due course, not to take up time now, but Lord Steyne speaks to like effect between paragraphs 22 and 25. So those are pages 710 to 713. And Lord Hoffman at paragraph 36, that's page 715. And each of those speeches are expressed in terms of giving effect to the purpose of the provision. Second authority, moving on in chronology, is the ZYN case, judgment of my Lord Legate, begins at page 653, and in particular it's my Lord at paragraphs 45 through to 47, beginning at page 664. While I start at paragraph 45 with, I may say, so the general observation, it's not difficult to see why an updating construction of legislation is generally to be preferred. We do rely on what my Lord has to say in paragraph 45, noting in particular that one of the changes that my Lord identifies as being relevant when considering always speaking is a change in technology. Letter D. 46, also of some relevance, we say in our case, the generality of language used by the legislation may also support the implication that it was intended to accommodate change. We would say the same is true here of a newspaper. It is of some relevance that the case my Lord goes on to identify was the Edison Telephone Company and the meaning of telegraph, whether that might extend to telegrams and telephones. And the answer was yes, because that again gave best effect to the purpose of the relevant provision. So we endorse what my Lord had to say in those paragraphs. And then lastly, this court, relatively recent times, the test claimants in the FII litigation. It's a long report that begins at page 926. The court split into a majority of 4 and a minority of 3, 7 members of the court. And the majority deal with always speaking from paragraph 215 onwards, which is page 1022. This is in the context of mistake of fact and mistake of law in the Limitation Act. So page 1022, heading discussion of Kleinwort-Benson, paragraph 215 onwards. And then in particular at 218, there's discussion of the always speaking principle. And in particular between letters C and D on page 1023, the always speaking principle is also invoked where the question arises whether a statutory expression should be interpreted as including a novel invention or activity which does not naturally fall within its meaning and was not envisaged at the time of its enactment, but which may nevertheless fall within the scope of its original intention. And the minority deal with the equivalent point beginning at page 1038, paragraph 267, and then in particular at 269 onwards. Page 1038, 269, the guidance regarding the ambit of the always speaking doctrine is in fact concerned with the fundamental underlying issue of whether Parliament can be taken to have intended by a statutory provision passed at one point in time, using language directed to the circumstances at that time, to cover a new set of circumstances which has come into existence since then. And we do rely on what they say in that paragraph 269 and 270. They endorse again Lord Wilberforce in the Royal College of Nursing case.
So the approach, you would say, is the same?
On that, we discern no difference between the majority and the minority. It's expressed slightly differently, but not to meaningful effect.
Yes.
As the court will be well aware, this always speaking approach has been applied in social contexts. So there's a case called Fitzpatrick about the meaning of family. It's also applied in the context of new technology. So there's now quite an old case called Grant about whether a document includes a tape recording. And there's a case called Victor Chandler about whether an advertisement of betting included an advert through the medium of teletext. Held that it did. In Victor Chandler, even though that gave rise to a criminal offence for which the person indicted was convicted. So we say as a matter of principle, that approach should apply here to the term in the VAT Act to reflect the technological developments in the publication of newspapers, not least because the digital edition falls within the same genus as the print edition, but equally because that conclusion best gives effect to the purpose of Parliament. Indeed, one might think this is a classic case in which the always speaking approach should apply. Not least because that exercise of comparability was done here by the first tier tribunal when it concluded that the print and the digital editions are fundamentally the same. Now,
and for this purpose, you have in mind the digital edition which reproduces the paper edition.
I say that as regards all the digital editions because that was the finding of fact. It extended to all of them.
Yeah.
But it is at its most acute in the e-reader, which is a PDF. So one could open it on screen, and what you get is a PDF page of the Times, which you then flick from left to right. And the Commissioner's case here is that if I walk to my newsagents in the rain and I buy a print copy, it's 0 rated. I sit at home and download the PDF version and read the same page, it's standard rated. And we say they all fall within the same genus, and they all give effect to the same policy. So that's the UK legislative position. I do now need still to address the EU legislative regime, because your lordships will be aware that VAT is an EU-derived tax designed to be uniform across all member states, but it is still not yet fully harmonised. So there are certain aspects of the VAT code in each of the member states, whether for historical reasons or by virtue of political or policy choices made by those member states, that remain domestic law that is, I'll put it slightly crudely, tolerated by EU law, but not itself governed by EU law.
Just before you move on to the EU position, I'd like to come back to the question that is troubling me, even if we were viewing this purely through the domestic eyes. And that is that once you have set in place this always speaking purposive approach, one then, I think, has to face potential difficulties with that approach. And one potential difficulty is if Parliament has subsequently explicitly dealt with the matter, how one then deals with that aspect, because it seems to me it would be odd if you're applying an always speaking approach that you don't take account of developments in the law and somehow put that out of your mind. So one has to take account of not only scientific developments, but developments in the law. And one of the developments in the law here is that Parliament has specifically dealt with digital editions. And one, I think, has to face up to whether that produces a problem for your analysis. Now, I therefore come back to the question, first of all, Parliament has specifically dealt with it. And secondly, it specifically dealt with it in a way that cuts back, in some respects, I think, on what you've been telling us the meaning of newspaper is. Because Parliament has said, but not if the primary or whole predominant aspect is video or audio. Now, it may be that you... Well, sorry, I'll stop there. That's a problem that's going through my mind.
My Lord, yes. And if I understand your Lordship's observation, I think it may have three parts. Your Lordship will tell me I got that right or wrong. But there is a question as to whether one can take anything from the terms in which Parliament has legislated in 2020 when one is construing or seeking to understand the purpose of Parliament in 1972 or here in 1994. And I say no to that, because the purpose of the provision has to be gleaned from the language that was used, strictly here, firstly in 1972, but latterly in 1994. And the fact that Parliament has legislated in the field in 2020 doesn't tell you anything about that original purpose. And there is an observation of Lord Neuberger in a case called Boss Holdings to that effect.
Do you have a reference for that?
It begins at page 491, and his particular paragraph is at page 496. It's paragraph 23. 496 and 497. So that's the first aspect of what my Lord may be asking me. The second is, as a matter of principle, does the fact that Parliament has later legislated in or near this field mean that the court can't apply an always speaking approach? And the answer to that is we say no. And there is authority for that. Now, I'm afraid the case itself is not in the bundle, but we can provide a reference. But it's discussed in the Benyon extract that is in the bundle. If Your Lordship would just take from me for a moment the Benyon reference, that begins at page 1070. One of the aspects of the principle that is considered in Benyon is at page 1083. I'll just read you the passage towards the head of that page. The fact that since the events in question in a case, the relevant enactment has been expressly amended to update its terminology does not mean that the original language is not to be given an update in construction, producing a like effect. And there's a footnote reference there to a case called R and Fellows, which is a criminal case. I'm afraid that's not in the bundle, but we can provide Your Lordships with a copy. And what the court said in that case was, in effect, the fact that Parliament had later changed the law didn't tell you anything about the applicability or otherwise of the always speaking principle. Because what you're concerned with is the original genus of fact and the original purpose. And Parliament legislates, but that doesn't allow a conclusion that always speaking is barred. Now, the third aspect that my Lord may be putting to me is this, that does the fact here that our particular statutory language, which refers to a publication of a newspaper electronically, but then has exclusions in the form of little a and little b, is that either a barrier to my case or inconsistent with my case? We say no, because what little a and little b are doing are making clear or are expressly excluding that which would not otherwise be a newspaper in any event.
I think my response to those very helpful submissions, if I might say so, are that I would accept what you're saying in your propositions 1 and 2, or submissions 1 and 2. It's the third that's bothering me, whether you potentially have to avoid incoherence or inconsistency. You couldn't, I think, apply the always speaking doctrine if it would start to produce legal incoherence. Now, the third submission you made is it doesn't produce legal incoherence here.
Yes.
That effectively that provision is simply a clarificatory provision, and I assume from what you said that therefore one would read that as having always been the position.
Lord, yes.
So that your definition of a newspaper that you gave us before is going to have to be amended, because you are, I think, accepting that it cannot have a wholly or predominant audio-visual or advertising content. Is that right?
But I would have said that had we been having this debate in 1973,
Yes.
I would have said exactly the same thing. The newspaper does not extend to matters that are wholly advertising or wholly or partly audio or visual.
Right. So you say that was always the case and there's no incoherence for that reason?
My Lord, yes.
No. Wholly advertising or primarily advertising?
I think the phrase is it's wholly or predominantly.
Predominantly.
Well, wholly or predominantly devoted to advertising, or wholly or predominantly of audio or video content.
But we're here concerned with tax during the period 2015 to 17, or earlier period?
2010 to 2016.
2010 to 16, when the 2020 legislation did not exist.
Correct.
It would be quite a novel principle, wouldn't it, to say that the meaning as it's given to it now should be different from the meaning that should have been given to it in 2014 because of something that's been enacted subsequently.
My Lord, yes. Now, one rider to that is the claim period that is the subject of the appeals is 2010 to 2016. My clients have since claimed between 2016 and May of 2020. And that claim is either good or bad, but it stands or falls with the rest. So we do run up to May 20. But your Lordship's point is one we would accept and endorse. But to come back to my Lord's point, we cited some authorities below. We looked around the English-speaking world, can we find an authority about the meaning of newspaper? And we produced almost nothing. There's a couple of Australian cases. One is about a betting guide as to whether that was a newspaper. And so one can find some vaguely helpful dicta about what is a newspaper, but the upper tribunal and the Court of Appeal didn't find them particularly significant, and they're no part of my case now. But the proposition that something that is wholly or predominantly advertising and is not a newspaper is a proposition that I feel entirely comfortable with.
I mean, there are certainly examples, I'm sure, that we're all familiar with, of what might generally be described as a newspaper, which is predominantly advertising and which may be largely funded by advertising. Some local publications in parts of London, for example, were absolutely packed with advertising, and one would imagine that was how they were financed.
My Lord, I'm in danger of giving evidence, but nearly all of those free newspapers have some editorial comment.
Yes.
And typically a lot of estate agent advertising. And I don't know this, but that's perhaps what allows them to be seen as newspapers.
Yeah.
But that then is a problem for you, is it not? Because the exclusion that you're talking about only really starts to make sense if we're talking about electronic services.
Well,
so it can't just, can it be, about the definition of newspaper?
Well, one can see tolerably clearly the rationale for little a and little b in what is item 7, that Parliament wants to draw a distinction between pure digital advertising, or that which is only audio or video on the one hand, and newspaper on the other. But the place it's drawn the line, in my submission, gives effect to the meaning of newspaper and produces legal coherence. It doesn't produce legal incoherence.
But I think what I'm putting to you in the light of Lord Kitchen's question is that we might accept that a print copy of a newspaper could be mainly advertising and yet still sensibly be classed as a newspaper, whereas we couldn't do that with the digital edition. So that, in fact, the exclusion makes perfect sense in the digital context, but but doesn't make much sense in relation to the printed copy.
But look, there is another logical possibility, perhaps the lordship is discounting, which is when Parliament enacts item 7, it's giving effect to the 0 rating of newspapers, but it can, of course, make a separate decision to exclude what would otherwise be a newspaper in pursuit of some separate 2020 policy goal. To take a try to no doubt unrealistic example, it might have said digital editions of newspapers are 0 rated, but only for daily newspapers, not for weekend newspapers. And had it said that, that would be a separate exercise of Parliament's choice that respects still the concept of newspaper, but makes a 2020 decision to limit 0 rating.
But that would then, on your submission, mean that the law between 1994 and 2020 was wide enough to include newspapers that were predominantly advertising, even if digitally, but suddenly there's a new policy that restricts that in 2020.
Well, that's not my case, but I'm just attempting to meet your lordship's observation that does the logic of my position give rise to this incoherence that the court ought to avoid?
Yeah.
And I'm saying no, because what in our submission A and B are doing is in effect restating that which is a newspaper. I do take my Lord's point that it would be an odd state of affairs if the way Parliament has expressed itself in 2020 should be seen as cutting down what is otherwise the ambit of the term, at least between 2010 and 2020.
Well, I wonder about that. In the absence of the 2020 edition, then the newspaper of which Lord Kitchen spoke, one which was predominantly advertising but nevertheless had news in it, would, to any viewer back in 1972 or in 1994, be a newspaper. You're relying on hindsight, really, of the 2020 reform to reinterpret what the situation was earlier.
Well, that is true, my Lord.
Which might suggest that there is an element of incoherence, as Lord Burrows suggests.
Well, we wouldn't accept that as the conclusion there, because, of course, this legislative change was made after this litigation started.
Oh, yes.
So when we first started this debate, we were only looking at the 1994 Act. We didn't have the benefit of the change that was made in May of 2020. But both before and after May of 2020, our case is the same, that the newspaper has certain core characteristics which are present in the case of the Times, the Sunday Times and the Sun, where the underlying purpose is the same, and the fact that the law has changed in favour of my particular clients, so the Times, the Sunday Times and the Sun, is not a good reason to conclude that newspaper didn't have the always speaking interpretation that we favour.
Thank you.
I made my point that the UK legislation here sits within the framework of European law, and the UK's 0 rating is one of those non-harmonised aspects. But if I raise this point, a point I may need to...
In the legislation, sorry, I'm just thinking that the 2020 legislation, it might be argued to change the meaning of newspaper from that point on, but I don't see how it could possibly change its meaning retrospectively. What it meant at the time when these events happened surely can't be decided one way or another by reference to something enacted later, just as a matter of legal principle.
We would say yes, my lord. Now, one marker that I may need to come back and develop in reply. I'm going to show your lordships in a moment that one of the constraints of European law, as your lordships will have seen from reading in, is that the relevant EU law must be strictly interpreted. Now, there is a question, perhaps a question of principle between the parties as to whether that necessarily means that you can never apply an always speaking approach to a provision that is subject to a strict interpretation. Now, that was not said below by Mr. Plemming for the Commissioners, and that's recorded in the Court of Appeal in paragraph 52, Roman 4, key document, page 80. But it does seem to be said by my learned friend's written case in various places. And so that may be a point of principle, a divide between us that I want to come back and examine in reply. So with that marker, I then turn to the EU legislative regime and its application here. Your lordships will perhaps have seen that in EU law terms, the UK's zero rating is a species of exemption from VAT. But in the jargon of European law, it's exemption with a right of recovery at the preceding stage. And civil VAT codes before the 6th directive provided in some circumstances for an exemption, but with the right of recovery of the VAT at the preceding stage. And one of the debates in 1988, when the European Commission launched infraction proceedings against the UK, was whether the UK system of zero rating was in effect the same as that exemption with a right of recovery at the preceding stage. The Advocate General and the Court say yes, and that's in the European Commission case, 1988, the head notes at page 279. And just how UK law fits with European law here is helpfully set out by the Advocate General at page 285. Paragraphs 1 to 5. This is Advocate General Darman, and he explains the UK's zero rating system and how it fits in. And in particular, paragraph 5 on page 285, let me state right away that the system itself is not challenged by the Commission. The UK system of zero rating is perfectly permissible. And that's also reflected in the Court at page, beginning at page 293, it's paragraphs 1 to 4 and paragraph 10, in particular paragraph 10, page 295, the Commission does not dispute the legality of the system of zero rating in general. It considers the system to be essentially equivalent to the exemptions provided for in Article 28. But the UK's exercise of its own policy choices to make provision for zero rating had to be for clearly defined social reasons and for the benefit of the final consumer. And in 1988, the European Commission brought proceedings against the UK on the basis that certain of these zero ratings either did not meet the clearly defined social reasons or were not for the benefit of the final consumer. And Group 3 newspapers was not challenged. So the UK had the ability, originally under the 2nd directive, then later under the 6th directive, now under the principle of that directive, to maintain the zero ratings that it had in place, subject to what's called the standstill. I'll put it broadly for a moment, namely that the footprint of the UK's zero rating should not be expanded.
That's your expression, the footprint.
No, it's used in some of the authorities, but I'm going to come back and I want to put it much more specifically in a moment. But the standstill was originally expressed as at December 1975, and then later it's expressed as at January 1991. I'll come to that in a little more detail in just a moment.
But the 1991 footprint wouldn't, or the 1991 standstill would not broaden, couldn't broaden the footprint if one was subject to the earlier limitation, the earlier standstill in 75.
Correct, my lord.
Yes.
That they run in sequence, yes. And there might be a debate about if you removed a zero rating and put it back in between 75 and 91.
That didn't happen.
It didn't happen, and we're not concerned with that. So, although it's expressed in terms of January 1991, for our purposes in this debate, it's the same as it was in December 1975. But because the UK system of zero rating is a derogation from the ordinary standard rating across the whole of Europe, it's treated as if it were an exemption, and it is subject to the general rule that exemptions should be interpreted strictly. Now, there is still a debate even now as to exactly what does that mean. Most recently addressed in this court in the SAE education case by my Lord Kitchen at page 869 in the authorities. This was a case itself about an exemption, although it applies equally to zero rating. This was about whether education provided by a college of a university was exempt or not. So the head note's at 857. The relevant paragraph is my Lord's paragraph 42 at 869. So the terms used to specify exemptions, or here zero rating, must be construed strictly. Nevertheless, they must also be construed in a manner which is consistent with the objectives which underpin them, and not in such a way as to deprive them of their intended effects. That has been put in almost identical terms by the European Court in a case called Hadera. The head note is at page 327, and it's paragraph 18 at page 331. In particular, at letter G, the requirement of strict interpretation does not mean that the terms used to specify the exemptions should be construed in such a way as to deprive the exemptions of their intended effect. So the way my Lord put it is, in effect, identical to the way that the European Court puts it. Now, we do say that a requirement for strict interpretation doesn't necessarily mean the most restrictive. And that's a point that's made in paragraph 24 in Hadera. It's page 332. In particular, although the terms used to specify the exemptions are admittedly to be interpreted strictly, a particularly narrow interpretation of school or university education would risk creating divergences, the application from one member state to another, as the member states' respective education systems are organised according to different rules. Such divergences will be incompatible with the requirements of the case law referred to in paragraph 17 of this judgment. So the court even there is wary of giving a term a particularly restricted interpretation where that might undermine the relevant policy. So one has to approach here the zero rating provision strictly, but not in the most restrictive way. We also have to give effect to the standstill, and that standstill is now provided in Article 110 of the Principal VAT Directive, which is page 8 of the authorities. In particular, top of page 8, member states which at 1st of January 1991 were granting exemptions with deductibility of the VAT paid at the preceding stage or applying reduced rates may continue to grant those exemptions or apply those reduced rates, but they must be in accordance with community law and must have been adopted for clearly defined social reasons and for the benefit of the final consumer. Just to note my Lord Hodges' point, the UK is subject to that 1st of January 1991 and before that December 1975 because we acceded to then the EEC on the 1st of January 1973. Different member states joined on different dates. So different member states have different standstill dates. So, for example, in Article 111, provision is made for Finland and Sweden, and they acceded in January 1995. And 111 is of some interest to us because it ensures that Finland can maintain its existing treatment for newspapers and periodicals sold by subscription. And little b, Sweden is allowed to maintain its treatment of the supply of newspapers, including radio and cassette newspapers. The newspapers there is being used in the sense of a non-print edition. Now, those provisions are not directly material. They're just examples of other states with other standstill dates. So member states can maintain the existing zero rating derogation. We then say, well, there are 6 important points to note about this provision. The first I've touched on is that it now refers to January 91. It used to refer to December 1975. One can see that from the relevant editions of the VAT directives, in particular pages 29 and 33 of the bundle. Secondly, I've made the point that Article 111 have different dates for different member states. It interestingly uses radio and cassette newspapers as regards the position in Sweden. Thirdly, and more importantly, member states were allowed to retain such special treatment to avoid the social hardship that would or may arise if the special treatment were taken away and the standard rate imposed. And that is the effect of a decision of the European Court of Justice in a case called Talica, which is important to the debate between the parties. So can I invite you to turn up Talica? Head note is at page 415. This is a reference to the Court of Justice from the UK. And Talica Talika sold beach caravans, and the caravans were zero rated. But there was an express UK statutory provision that said the contents of a caravan are standard rated. By way of digression, there's a separate principle of VAT law that says if you make a single supply rather than separate supplies, that single supply should only have one rate of tax. So what Talika said was, well, we make a single supply of the caravan and the contents, therefore that ought to have a single zero-rated rate. And the UK government said no, because what you're doing there is overriding the express statutory provision in the UK that says you can't zero-rate the contents of a caravan. So the question for the European Court was, bearing in mind this developing law about single or multiple supplies, if you conclude that it is a single supply, does that mean that Talika could treat the caravan and the contents as being zero-rated? And the court say no. Now, the reason the court says no is because that would override the express exclusion in the UK statutory code for the contents. Now, I don't want to take time in reading all of these passages out to your lordships, but the Advocate General, in particular paragraphs 15 through to 26, bears careful reading. That's pages 419 through to 421. What the Advocate General concludes is that you can't use this single supply analysis to override the UK statutory provision. And then the court judgment begins at page 425. And again, it's the court from paragraphs 14 through to 24 bear careful study, and that's pages 426 through to 428. But because this is part of the divide between the parties on this appeal, I ought to look a little more closely at what the court says in paragraph 16. So the bottom of page 426, dealing with the UK's zero rating, it says, since one of those conditions is that the derogation had to be enforced on the 1st of January 1991, the exemption with refund of the tax paid cannot be extended beyond the terms specifically laid down by the national legislation. And then paragraph 17 makes the point that it's a derogation, and then paragraph 18 grounds this in the second VAT directive, has to be for clearly defined social reasons and for the benefit of the final consumer. And then paragraph 20 notes that the VAT Act specifically excludes some items supplied with the caravans. So it specifically excluded the contents. And in 21, the court says this: therefore, an exemption with refund of the tax paid in respect of those items would extend the scope of the exemption laid down for the supply of the caravans themselves. That would mean that items specifically excluded from exemption by the national legislation would be exempted nevertheless. And paragraph 22 makes the point that the standstill is there to prevent social hardship likely to follow from the abolition of exemptions. And then at the end of 22, having regard to that purpose, the content of the national legislation in force on the 1st of January 1991 is decisive. So the court there is saying two things of relevance to our appeal. One, you have to take a strict approach to zero rating. And two, because of the purpose of the standstill, the zero rating cannot be extended beyond the terms specifically laid down by the national legislation. Now, in Talika, that was an easy-ish decision to reach because there was an express exclusion for the contents. If you allowed the single supply to override that, you were departing from the terms laid down by the national legislation. So the actual decision in Talika is a rather narrow one. How the court expressed itself is material here because we are told that given the purpose of the standstill and the fact that the UK zero rating is a derogation, that derogation cannot be extended beyond the terms specifically laid down by the national legislation. So here, one of the points against me is that if we give a particular interpretation to newspaper, that has the effect of extending the terms of the national legislation. And we say, no, that's not right. There is an important difference between an extension of the categories of zero rating, brackets not permitted and exemplified by the taxpayer's argument in Talika, and the application of those categories in light of ordinary UK principles of statutory interpretation, which is permitted. So if one takes a very prosaic example away from the facts of this case, food for human consumption is zero rated, has been since 1972. Confectionery is an exception from that and therefore standard rated. Biscuits are an exception to that exception and therefore zero rated, unless they're wholly or partly covered by chocolate. And so there are debates in the tribunals and courts below as to whether a particular product that comes along, is it a biscuit? And there's a case we will no doubt come to in a little while about meatballs, where they fit into hot food and cold food. And the courts have to decide whether an item is a biscuit. But if the court comes to the conclusion that a new product is a biscuit, that is giving effect to a category of zero rating that was in place in 1991, indeed all the way from 1972, the courts are not thereby expanding the scope of the zero rating. They are simply giving effect to it. And that exact point was made in a first-tier tribunal decision, a case called Harrier. Head note is at page 599. This is a case about books, photo books. So the facts don't concern us. Paragraph 66 on page 615, we say is apposite and relevant to our dispute. Mr. Thomas, counsel for the commissioners, submitted that to treat the photo books as books or booklets within item 1 of group 3 would extend the scope of the zero rating provision beyond its terms and evidence scope and would thus amount to an illegitimate extension of the derogation authorised by the 6th and now the principle of that directive. To the extent we've decided that certain of the photo books do fall within the ordinary meaning of those terms, we do not agree. The derogation authorised the continuation of an existing statutory provision, and we have decided that on its proper construction it encompasses certain of the products at issue in this appeal. That is a recognition of the scope of item 1, not an extension of it. We say that is apposite in our case, So what the courts and tribunals are doing when deciding whether a particular item does or does not fall within the ambit of a statutory term, my example biscuit, but here newspaper, a decision that it is included is to give effect to the provision, not to extend it. And the same is true even if it's an entirely new product. So biscuits were around in 1972, but one could do exactly that same logical exercise if we contemplated a form of food that wasn't around in 1972, and the only one we can think of easily is lab-grown meat. Certainly not in the contemplation of Parliament in 1972, but you just have to decide, is it food for human consumption? But a conclusion that it is simply, in the language of Harrier, giving effect to the ambit of the term that Parliament used in 1972, repeated since then, and not extending it. And that principal divide between giving effect to a provision and its extension was recognised in this appeal in the upper tribunal, in particular at paragraphs 51 and 90. That's key documents, pages 102 and 112. We say, with respect, the upper tribunal got this absolutely right. So the effect standing back is the UK cannot introduce an entirely new category of zero rating. Take an example, again, relatively close to our facts. The UK couldn't decide that streaming of music was zero rated. That would be an entirely new category. But this court can decide that on a proper interpretation of the relevant term as a matter of UK law, a digital edition is a newspaper, and that does not give effect to an extension to the zero rating. It simply gives effect to the zero rating.
So if that's correct, if Parliament in, let's say, 2002 had enacted a piece of legislation that said digital newspapers will be zero rated, you say that that would not be contrary to the standstill provision?
Correct.
It would just be clarifying what had been permitted from the start?
Yes, it's giving effect to the conclusion that I'm inviting this court to reach as a matter of UK statutory interpretation. Purposive, contextual, giving effect to always speaking. And if you're not with me that far, then I can go no further. But if you are with me that far, I say I don't thereby contravene EU law, because there is in effect a live rail that I've not stood upon.
If you were wrong in your interpretation of newspapers, then if there were such a provision enacted in 2002, if there had been, it couldn't help you, because it would have been then extending the meaning of the provision.
There would then be a different debate as to whether the UK can legislate in breach of European law, and whether the courts can give effect to that on the assumption that Parliament has decided deliberately to breach European law. But we're not in that debate. And there is one point I should have made actually at the opening, that if I mentioned the B word, Brexit, our relevant period here is all pre-Brexit.
Yeah.
So this is why we say the Commissioner's case is not clear whether they say that applying an always speaking interpretation here is automatically barred because it would always extend a zero rating, or whether they're only saying that in the circumstances of this case where we're concerned with newspapers. And I say as a matter of principle they're wrong about the former, and here in any event they're wrong about the latter, because there's nothing in an interpretation of newspaper which encompasses a digital edition that would contravene these EU law principles.
Well, either they're right about meaning newspaper in the first place, in which case they don't need this point, or they're wrong, in which case it doesn't help them.
Well, yes, that would be right. Now, my sixth and last point in relation to the EU law framework is that there are two purposes one needs to keep in mind here. One has to identify the original social goal or social purpose behind the UK's choice of zero rating for newspapers, and that's what was found by the first tier. And there is a separate purpose behind the standstill, which is in effect not, it can be put in two ways, not to allow the member states to add to their categories of zero rating, and putting the same point the other way around, it's to allow the member states to continue with the zero rating they had, to avoid the social hardship that would follow from the imposition of standard rating. So drawing those threads together, ultimately we're concerned with the application of the VAT Act 1994 between 2010 and, in effect, 2020. The language in Group 3 in 1994 is the same as it was in 1972, by which the UK sought to zero rate newspapers in furtherance of that social policy. It's permitted to maintain that zero rating by what is now Article 110. And we say, and the first tier tribunal agreed, that the purpose behind the policy choice made by the UK in 1972 is just as satisfied by digital editions as by print editions, and they are fundamentally the same or very similar, so the same genus. So read by way of a modern construction, recognizing all we're speaking, the term newspaper as it appears in Group 3 should be seen as applying to digital editions, and a conclusion to that effect neither contravenes the requirement that the zero rating should be interpreted strictly, nor does it offend the standstill. Now, still under the EU heading, there was a lot of debate in the tribunals and the court below about the significance or otherwise of some different EU legislative provisions that deal with reduced rates. I don't want at this stage to get bogged down in the detail, but in the same way that the EU VAT code makes provision for member states to have zero rating, it also makes provision for member states to have rates of tax that are positive but lower than the standard rate of tax. They're referred to in the jargon either as reduced rates or super reduced rates. And different member states have different special treatments for political reasons in given member states. And the Commission has said below, well, once you look at those provisions and you look at the case law on those provisions, where either member states or commercial operators in member states have tried to get equality of treatment between books and electronic books, seeking in each case reduced rate treatment, and you can see that the court has moved in stages, and then the European Parliament has legislated in stages, such that there is now no difference in reduced rate terms between a supply of a book in paper form, or a book on a DVD or a CD, or a book in electronic form. That change came in 2018. The commissioners say, well, because that legislative code for e-books has developed piecemeal, you can infer from that something about the scope of zero rating in the UK. And my stance has always been, no, that's simply irrelevant to the statutory exercise we're engaged upon. And in the Court of Appeal, we had that debate again. And in my lady's judgment, Lady Justice Simler, she finds some support for then Mr. Plemming's view of the world in the fact that the European Court and the European Parliament had progressed by stages in dealing with e-books. I don't want to take time up now, I'll come back to it in reply, but just as a headline answer, we say again that case law and the legislative developments in relation to reduced rates and Article 98 has no bearing upon the exercise of UK statutory construction that this court is engaged upon. That would take me to my fourth principle heading, which is the principle of fiscal neutrality.
Just before we go to that, a couple of these directives. So what was the directive 2018/1713 doing in your submission?
It was to give a full answer to Muller, one needs to read the events chronologically, and I don't want to do it now, but if I just give you the waypoints.
Certainly. Maybe you want to come to this later.
Well, I was going to come to it in reply if my other friend makes something of it, but if I give you the answer now, my lord, and then we'll see if I need to.
I wasn't sure that I wasn't asking a rather different question than what you were hoping to deal with in reply, but
one needs to look at Article 98 dealing with reduced rates, and then there's a separate concept in EU VAT law of an electronically supplied service. And so there was a debate then as to whether those rules providing for reduced rates in certain circumstances applied to books and books on physical means of support. This is a world, one may remember, one could buy a CD with a book on it or a memory stick with a book on it.
Yeah.
And that was the subject of some litigation from Finland in a case called K-OI in 2014. And the head note to that is at pages 348 and 349. There was then some infraction proceedings involving Luxembourg about books and e-books, and that's at page 249, and that was in 2015. And then there was a further debate involving Poland in the RPO case, which we looked at briefly in 2017, about e-books. In particular, one needs to look at pages 405 to 407. And then the European Parliament responded to what was a fairly messy state of affairs across Europe in the directive in 2018. In particular, one needs to look at page 22 of the bundle. That allows member states to apply reduced rates to books and newspapers supplied electronically. It was dealing with reduced rates, but it also allowed member states which were zero rating items on physical means of support to apply a zero rating to digital editions. And in particular, one needs to look up, if one turns up page 22, In particular, it's recital 3, my lord, that identifies the ambit and refers to the RPO case. It deals with zero rating books, newspapers or periodicals supplied on physical means of support to ensure that they got the same treatment as books and newspapers supplied electronically. And that is the operative effect on page 23 of the amendments made by Article 1. So in answer to my Lord's question, it's dealing with reduced rates, not our case, and in effect with zero rating, that is our case. It is dealing with newspapers, that's our case, but it's dealing with books and newspapers on physical means of support to ensure that the digital editions are given the same treatment.
So if we look at the whereas provision 3 preamble halfway down, therefore it's appropriate to introduce the possibility for all member states to apply a reduced VAT rate to the supply of books, newspapers and periodicals, irrespective of whether they're supplied on physical means of support or electronically. Now, if we take the UK position as you submitted to be, the UK is already in the position of an exempt VAT rate for electronic newspapers.
My Lord, no, there's an important distinction here between the UK's exemption with a right of refund at the preceding stage, i.e. zero rating, and a reduced positive rate. And that sentence your Lordship has just read to me is concerned with reduced rates.
Right.
So the reduced rate for most of our period, I think, was 15% in the directive. You were allowed a reduced rate, I think, of 5, I'll look this up, and you were sometimes allowed a super reduced rate of 3.
But as far as the UK position is concerned, it was already zero in any event on electronic newspapers on your submission.
Which is different. Because, and maybe I should show your Lordship this, Article 98 is part of the harmonised position. So if one turns back to page 7, Article 98 is part of Section 2 of what's now the principle of that directive. And this is all, Section 2 is harmonised. All member states have to comply with Section 2. Article 110 is part of Section 3, which is not harmonised. So the directive is dealing with the harmonised world when it deals with reduced rates, but we are a zero rate in the non-harmonised world. And my Lord, that distinction really matters, because if we're in the harmonised world, the UK VAT Code has to comply with all of European VAT law. But when we're in the non-harmonised world, we make our own policy choices, provided we stay within the boundaries of strict interpretation and the standstill. So in headline answer to my Lord's question, we say that directive is addressing a different part of the VAT world. It's doing it in 2018 to bring clarity to what was a fairly messy picture as a result of the decisions of the Court of Justice. But it doesn't have any bearing, we say direct or even indirect, on the exercise of statutory construction that the court must make.
So the 2020 UK legislative reform had nothing whatever to do with this directive, is that right? It wasn't paving the way,
no,
in any sense.
Well, if I might just think over the short adjournment about that question and come back to it. But
yes, certainly. Of course.
Doesn't it have a separate provision that is paving the way for it? That's not altering the reduced rates regime, but is altering the zero rating regime. Or am I wrong about that?
That's what I want to check, well, I'll just have a short adjournment to make sure I give your Lordship an entirely accurate answer.
Given that's an important question, and given that you're otherwise moving on to a new topic, would this be a convenient point at which to take the short adjournment?
Good, my Lord, yes.
So then we shall do so. Thank you very much, Mr. President.